Hi everybody, I'm immigration lawyer John Khosravi. Thank you for joining us again today for our regular Wednesday live Q&A where I'm taking your questions for general education purposes about U.S. immigration. We're here every Wednesday at 6 p.m. I don't think we've missed one. At most, maybe we missed one, but I doubt it. I think it was like the Black Lives Matter thing where you're not supposed to post or else you get in trouble, so we gave in. So let's see, we're going to talk and take your questions that they're coming in. We have a lot of regulars who already posted questions. But I did mention this is general education only, you know, there's a couple of things I want to talk about. One important topic that popped up today I'm going to talk about K-1 fiance visas, so check that out. We're going to get into that in a second. A very troubling issue that I really want to break down for people watching, because I know the primary focus of my firm is marriage cases and fiance cases, and I know a lot of my listeners and watchers are doing that. One note before I get to that is I have a thing called the Ultimate Marriage Green Card Guide about the marriage green card process, and you can download it free at www.marriageimmigrationlaw.com, and through that you can get a better understanding of the general things involved in a marriage immigration case if you're planning on getting engaged or getting married, so you can plan this stuff ahead of time. So I guess with that, let's get it started. Before we get to your questions, sorry guys, be a little patient, but we'll get to it in a moment. Is an issue that popped up today for me, where I have a client who met somebody online and decided, hey, you know, I love this person, we want to get engaged and want to get married. And after reviewing the case, typically these are normal cases people meet online all the time. Almost vast majority of my marriage green card cases are people who met online and stuff like that. However, for a fiance visa, they had adjusted the rules in 2005. And the initials of the rule is called the IMBRA, the Immigration, I forgot what the Marriage Broker Act or something like that. And the goal of this act in 2005 is to bring better protections for foreign fiancés and foreign spouses coming to the United States, because, you know, Congress, the U.S. Congress thought that potentially there's people abusing foreign people, bringing them here and being abused in a certain way. So they passed certain requirements to be able to bring someone here. For example, if you're doing a fiancé visa, if you have a history of, domestic violence and stuff like that, they're going to prevent you from being able to use the fiancé visa program. There's a lot of other parts to it. But what really hit us in this particular case was where the petitioner had met the foreign fiancé through a website. Now, as I said earlier, most people are meeting their spouses or fiancés through a website. But there's a requirement that goes back to 2005 days. You gotta think old days, when they're marriage brokers, people you connect with and they say, hey, I need to bring a spouse. And many times these spouses were from ex-Soviet Union countries, Eastern Europe, Ukraine, Russian. You might the name they called it as a whatever idiom, or not idiom, but example, they say Russian mail order brides, for example. Because of the worries of abuse to these so-called Russian mail order brides, which is just not from Russia, it's from all the world, they said that if you are dealing with a marriage broker, which is an entity, there's a legal terminology for this, but generally it's an entity who is involved in the connecting people for relationships. Then before that marriage broker can connect you with a foreign person, they have to do a certain amount of things, like getting certain pieces of information from the U.S. person who wants to do a fiancé visa in the future, and provide that to the foreign person, or else you cannot use the fiancé visa program. Now, none of my clients in the past, and most of my colleagues too, have not dealt with people who found their spouses or fiancés later on spouses through a marriage broker. So it's not an issue that typically comes up. But nowadays, with the increase of using relationship apps to find each other, these apps and these websites may be considered as marriage brokers. Now, the typical ones you think of that are popular in the United States would not fall under this category, because there's an exception to being called a marriage broker, and it's something like this, where if the main goal of the company isn't to connect U.S. people, citizens, with foreign people for relationships and marriage, and they don't charge like different prices for men or women or for people in a different country, then it's fine. And typically, these Silicon Valley apps that we see don't have that, so it's not an issue. But this particular website, the prospective client had met their spouse from, put it out there when you go to them, and they said, listen, we're essentially mail order bride system, and where our job is to primarily connect you with foreign women primarily to be able to get them, marry them eventually. So the goal was for a marriage relationship between a U.S. person and a foreign person, not a U.S. person with another U.S. person. There's this really foreign and domestic categorization there, whereas a lot of the apps that you're using don't care. They just say, okay, you're in LA, it's going to show you the people around you. If you're in New York, if you're in Paris, it doesn't really matter. But this website particularly did that, and they charge men that are joining it, but they wouldn't charge women. So after reviewing this and just frustrated because of the answer I had to give to the client, I said, listen, this is a marriage broker in my opinion, and they didn't go through the proper procedure of finding of doing the background check. They need all this kind of stuff of you before they introduce you to your fiance. And now you're in bad luck because I don't think you could use the fiance visa program because of that. You'll probably have to end up getting married. And so, they weren't thinking about getting married that quickly. They had to plan that out. But it's very disruptive to their lives. And what's most difficult is just the fact that how would you expect a regular person who's just trying to find love to know about these archaic and complex rules that even many immigration lawyers don't know about it. It's not something I've dealt with before, and I have to do research just, the last few days on it once I noticed the website where they met. So be careful, be very careful as when you start down this path. It's just mired with landmines. And it's very difficult, and this IMBRA and the International Marriage Broker IMB can cause a lot of problems. I want to share that with you because we have a lot of couples here who meet online and are interested in the marriage green card case. Very important thing that pops up, and it just shows like with immigration, the laws are so intricate and each case has so many weird things involved that it's good to have a lawyer, and it's good to a lawyer that's going to check and recheck and search the laws and stuff. Because it's complicated, and if this person who was about to file on his own but decided to get a lawyer, he would have filed this, spent thousands of dollars, and then in 2 years or so, or a year to 2 years, would have gotten it now and just wasted that much of his youth and her youth and their lives and money. So it's really good to be careful, but I want to share that with you. All right, Marlon, one of our regulars, congrats on getting the green card. Says, I called the Social Security office and they said to send the hard copy of the green card, my passport. Is that good? Well, it's not good or bad. It's just a procedure that since COVID started that they're asking is people actually send these documents. I'm uncomfortable with that because they may lose it, but that is the procedure I've been seeing. If it's possible to go in person to talk with them about this stuff, that's what I would prefer to do. But it depends on how urgently you need their Social Security card. And right now, they're saying to mail it in, unfortunately. So that's just what we have to deal with. Thanks for tuning in again, Marlon. I appreciate it. Iman, another regular, considering that I have an I-130 and an I-140 petition, that's a family-based and employment-based case, is it bad for my record if I extend my stay B2 in the U.S. to an I-539? Will there be a bearing on that? Well, you could always make a request. Because you have petitions pending, you have to put it in the application. I think on the I-539 did ask if you have petitions pending, and it increases the chance of getting it denial. But Iman, I need to see the whole picture. It's way too case specific for me to advise what's going on. You have 2 petitions from an employer, and this is too complex for me to be able to answer something that specific here. Jazzy asks, do I get deported if I have domestic violence if I get a misdemeanor? So it depends. It depends on the state laws and how it's interpreted by the immigration authorities. For example, in California, if you do domestic violence with a weapon, I believe it is, and I don't handle criminal immigration cases, it's still considered a misdemeanor. Typically, a misdemeanor is not an issue, but that statute in particular in California is problematic and can lead to deportation. So as you see, I don't have enough information about your arrest, your conviction, what state you're in, and to review all that stuff. So the answer is maybe. I need more information. I can't answer that here. Nuaz asks, I applied for my I-824 based on an EWA green card. Please tell me about I-824. Well, I have a lot of videos about the I-824. This form is used to request USCIS make certain actions with a petition, approved petition or application. Primarily, it's when a person gets their green card in the United States and their dependents are overseas. And so you have to send the case out to the embassy system. That's the request you make from USCIS to send it out so the rest of the family could get the green cards through the embassy. Or you started your case in the US and you thought you were going to be here, but you left and you need to transfer the case out. There's other kind of things, but unfortunately it's a form that once submitted, it gets forgotten about by USCIS several times I've seen. And sometimes it takes a long time to follow up with them. So you should file that application the sooner the better. It also helps to lock in the age for CISPA, Child Status Protection Act. So when you say tell me something about it, I need to know what you need about it, because there's books written about this. You need to be much more specific about what your need is. And many times clients don't know what their need is because they haven't done this process before. So I need to talk with you to see what you need, and I can tell you what I need to tell you. Tell me what you want, tell me what you need. Shelby asks, any updates on I-751s? Well, the one update they had was that they extended the extension notices. So I-751 is for removal of conditions. If you have a 2-year marriage-based green card or 2-year investment EB-5-based green card, but that's less of those. Well, they did this for both of them, but the I-751 is the form you submit for marriage cases, and it takes a long time for them to get approved, between 6 months to 2 years on average. And so your green card is expired when you file that. So you need something that holds you over, and they usually give receipts. It was 1 year automatic extension with that receipt, then they made it 18 months, and just recently they made it a 24-month extension because they expect these to keep going. Many times, in most of my cases, we just file for US citizenship while the case is pending anyways, if it is. But when you talk about updates, like the previous question, we gotta know what's wrong with your case, what issue you have, so we give updates appropriate for you, because I could talk a lot about different things and get really complicated. I really need specifics of what you need. Next question, Arno asked, I tried to apply my citizenship application, but I mistakenly missed the Selective Service registration. Well, I'm really sorry about that, but thanks for bringing it up for a lot of people to know. The United States doesn't actively recruit and force people into the military, but they have a thing called the Selective Service Draft, which is when a U.S. person, whether a citizen, a green card holder, or even a person here illegally, the only people who don't have to register are people here on non-immigrant visas, like student visas. You have to register between the age of 18 and 26. If you don't, there's issues, and I think it's going to crime. I haven't seen them enforce it. But the bigger issue for foreign nationals is if you don't do it, that's a good moral character issue for applying for U.S. citizenship. So it'll take either 3 to 5 more years after the age of 26, depending on how you got your green card, to pass before you could file for citizenship, and unfortunately it pops up. When you adjust status in the United States, most of the time, USCIS will automatically register you for the Selective Service Draft if you're between 18 and 26. But for those going through consular processing, getting the green cards through the embassy, they should give you a notification piece of paper reminding you to do this, but most times they don't. And so people, usually it's the children of people getting green cards, the children getting green cards with them. They come here, have no knowledge of this, and all of a sudden they're hit really hard by not doing this, and it delays their ability not only to become a citizen, but there's restrictions on getting like financial aid and college tuition, this and that, if you haven't signed up for the Selective Service registration. So it's something to be mindful of, and unfortunately, that hits you. So I'm sorry to hear that, Arno, but sometimes they'll make exceptions, but talk with an immigration lawyer to see if you fall within any of them, or there's a time, so if you wait a certain amount of years, that's okay. We just have to count the days and the years to see what's going on with your case. But thank you for the question. Sir, Yas asks, I-130 for parent, do they need to have their birth certificate? I have my birthday showing their name, but unfortunately they don't have. Well, I think you asked this question last week as well, Yas. Yes, eventually your parents, each of them, will need their birth certificate. If none was ever issued, they have to get a certificate of non-availability potentially. It depends on what country they're from and what kind of issues they have and a lot of other factors, but for most people, if you want to get a green card, you have to provide a birth certificate. Now you can start an I-130 for a parent without their birth certificate, but later on, if they do consular processing or if they're here and they do adjustment of status, part of the main requirements is providing a birth certificate. But again, there's exceptions. For example, people in India born before like 1960, I think, there was no birth certificates issued. So they have to get a certificate of non-availability and find alternative documents to prove that who they are, what their name is, all this kind of stuff. It gets messy. Typically I see this with Indian cases, but you have an issue with like Yemen, for example, where historically they wouldn't, they didn't even have birthdays in Yemen. They don't even celebrate the days. So they don't have the document either. So you got to jump through hoops and figure out what to do with it. But I wouldn't start a case without having all the ducks in a row. But thank you for your question, Yas. Mario asks, hi John, I'm an F1 student and a fiance is a green card holder, EB2. Do I need to maintain my F1 status after filing for adjustment? Thank you. Well, it's a really typical question we get, Mario. First of all, congratulations on your plan to get married. It's wonderful news. The thing about adjustment of status, which is application for green card, if you're in America filing with USCIS form I-485, is you only need to maintain status until the filing of the adjustment of status. So I'd wait at the very least until getting the receipt for the I-485 before you would drop out of school if that's your intent. However, you preferably would maintain the underlying condition of the F1 student status and keep going to school and maybe get OPT later, because when there's a possibility, hopefully not, but you get married, things are good, but then something bad happens and you want to separate. And if you get divorced, it most likely will destroy the marriage green card case, and once that happens, you're out of status. So preferably you maintain the F1 status to hold you over in case there's mistakes, there's issues, and maybe USCIS accidentally denies your case if you refile. It's good to have that in order. Now, if your spouse was a US citizen and you submit the case and for some reason you missed some documents, made errors, and then they denied your case, then you're out of status. Now, if you're married to a citizen, you could just pick up a refile immediately. But if you're married to a green card holder, you can't if you don't have the underlying student visa status anymore. So there, Plan B and Plan C worries I have. It's not every case, 1 out of 100 this happens, but we see it happen. So preferably just keep the underlying status. Download the Ultimate Marriage Green Card Guide. It really goes over a lot of this stuff. It's going to help you out at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And if you wanted more information, just email my office and we schedule a consultation. There's a fee for that, but email me and we can discuss it. Mohammed asks, can F1 students shadow a doctor as it meets criteria for unpaid internships? It's one of those on-the-line issues. What you should do is talk with your school, your designated school official, and see if they could okay it, or if they have certain programs. They're probably going to say no, they're not aware. I prefer there not be unpaid internships. Maybe if there's for credit, I'd prefer you do it like that, school credit. But talk with your national department, and I would have to kind of jump in and have a private consultation. There's problems that can come out of this. I really want to be very careful and study exactly what you're doing and what the work is and all that kind of stuff. I'm hesitant to give individual legal advice on something like this because it could be problematic as unauthorized employment or something like that, and I don't want to give that advice without giving full attention to the case. So talk with the school and then talk with an immigration lawyer or 2 or 3 to get better advice on that. User 28 asks, is it difficult to immigrate to the US if you're 40 years old? Age doesn't necessarily make a difference. It's generally difficult to come to the United States. So age isn't really a factor in any immigration program I could think of. It just depends on if you have access. The US immigration system is based on 3 primary ways of coming here, 3 to 4. First is family-based, so it's not your age, it's like do you have a relative that's close enough. Secondly, it's employment-based, and so it depends on if you have a job, your education potentially, if you're extraordinary ability, if you're investing, not age-related. Third, if you're when the green card lottery, the diversity visa lottery, again, not age-related. And then finally, some people do asylum. Those are the 4 main ways people get status in the United States as immigrants, green card holders. There's some smaller ways, U visas or something like that, that eventually could lead to green card or some other things. But basically, that's it for the most part. So again, age doesn't play a factor primarily in those. Now, I mean, let's say you were a baseball player for 39 years, top of your game, and you retired at 40, you wouldn't be able to get a special baseball, top baseball player kind of green card. So it gets really nuanced if you're going to read it to age, but it's generally a non-issue. It really depends on your personal background and those factors I talked about who could start the case for you. 29 Super C1 Regular says, hi, good night, Attorney Khosravi. Can the debt ceiling not being raised impact the backlog even further? Also, I see your point about immigration reform being tough to attain. Yeah, 29 Super C, I think it's you and a couple other people always mention, what do you think about this regulation? Is that, who said it? A lot of people are doing clickbait kind of YouTube ads to try to YouTube videos about immigration and get a lot of views, and it works. But I always say, most of these are not going to work. The political process is way too complicated. And for those who don't know, there's this big immigration bill coming in, and the Senate parliamentarian, so no one's ever heard of this position, decided to take out all the immigration parts. I didn't know the parliamentarian was going to screw this deal, but I knew it was going to get screwed some way or another. That's why I don't bother following it. Now, the debt ceiling not being raised, it can be a problem because a big part of immigration is a lot of background checks you have to do with the FBI and a lot of agencies, and if they don't get funding, then your case stalls because there's no one to do your background checks. So yeah, it's going to be a catastrophe. It's happened before. It's not the first time this affected immigration, but yeah, it could definitely affect immigration. Now, USCIS works on user fees, and partially the Department of State does too, but not completely. And so all these agencies are going to get affected. They're not going to have funding. They're going to probably lay off people or put them on hold and not work. So you're going to see immigration consequences added on to how bad it is already with the delays. Although, really quick, I must say with regard to delays, we're getting citizenship cases and marriage adjustment cases in the US with USCIS happening faster than I've ever seen them. Some people are getting citizenship naturalization interviews a couple weeks after filing. We're getting green card adjustment cases in some cities 3 months after filing. So it's not typical. The same city that does a 3-month case might take a year and a half to do another case. So, you know, there's no rhyme or reason or logic or consistency. But in the United States overall, it's been pretty fast for a majority of cases. The embassy system, if you're overseas, that's where the disaster is. Mayra asks, hi, I'm from South Dakota. I have deferred action through DACA. Can I apply for an I-140 change of status? Probably not. It's adjustment of status, but probably not, because you have to maintain valid status in the United States if you're going to adjust status. And I don't know exactly what status you have, but deferred action is not considered status. And so because you haven't maintained status, you won't be able to adjust. You'll probably need to do consular processing. There's risk to that. This is a unique situation, so 100% you should consult in private with a couple of immigration attorneys that can review your paperwork, see how you got deferred action, what the basis is, and all this kind of stuff. But most likely, adjustment of status, which you're asking, is not going to be possible. 9 out of 10 times, but it might be an exception. Manchester asks, hi, I got my green card, but I don't have a passport. Can I use a re-entry permit as a passport? Also, could you help me apply? You got to schedule a consultation. We're going to talk about the re-entry permit. There's fees associated with it. Email me, we'll take from there. But can you use a green card? You have a green card and don't have a passport. Well, you have to see why you don't have a passport. You should be able to get one. If you got your green card based on being an asylee, you can get what's called a refugee travel document and use that as a passport. Not every country will accept the refugee travel document. Now, whether a country will accept a re-entry permit for passport purposes, maybe there are some countries that would. This issue hasn't come up, but I have to research it. But most of the time, when green card holders don't have passports, is because they're refugees, and so we get them a refugee travel document. So I do deal with cases where people don't have passports, but you don't explain why you don't have it. And if it's something outside of being an asylee or refugee, then we have to see why you don't have it. You should try to get it, and then research the country you want to visit to see what their rules and regulations are. It's going to be hard not to have a passport, or at the very least, a refugee travel document. But whether they'll accept a re-entry permit, it depends on the country. Probably most wouldn't accept it, but I haven't done enough research on that. Just Liz asks, I was brought in using a relative's paper as she's a citizen. Will this be a problem for doing adjustment of status? Unless you're a minor, it's the worst thing that could possibly happen to your case, because if you enter the United States claiming to be a citizen, then you're essentially doing the worst possible crime you can do in immigration. And it's again, unless you're a minor, maybe you say you didn't know, you're like a baby, then it's going to be a major problem. You definitely need to talk with the immigration attorney in private, Liz. Mario follows up, it is any complication when I file for AOS adjustment if I change my last name after I got married. No, but you have to list your new name on the applications. That's about it. Your green card will be issued in that new name. Monsoon asks, my N400 citizenship application, they send me received note, but my family name, one letter missing. What should I do? Well, contact USCIS and say there's an error on the online system for USCIS.gov. There's an option for these kind of errors and typos where you can fix it. So I'll just contact them through that to fix this error. Sam asks, hi Mr. John, can I travel overseas after just sending my package I-751 and come back before my conditional green card? You know, I need to know exactly the dates here, so I can't answer that, but you know, you should submit your case, wait for the receipt to come, and have the expired green card plus the extension receipt together for traveling purposes. I typically don't recommend traveling without that, but if you want more nuanced detail, I really need to sit down and see what's going on in your case. That's a general answer for this kind of situation. All right, everybody, thank you all for joining. We'll talk again next week. God bless. Be safe. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.